This past weekend, the People's United Party held its National Party Council, and coming out of that were several resolutions, one of which demanded that the law limiting access to the Saskatoon River be rescinded. It seems that the demands were just the beginning for the PUP. Today, they announced that the opposition party leader, John Briceño, has filed a claim challenging the constitutionality of the statutory instrument. Attorney Andrew Marszalek is the legal advisor for the PUP.
That a claim was filed yesterday challenging the constitutionality of the Saskatoon law. This is the statutory instrument that was recently passed that you're well aware of, which restricts freedom of movement within the Saskatoon River, within an area in the Saskatoon River. The claimant is John Briceño, and the named defendants in the claim are the Attorney General and the Governor General of Belize. The basis of the claim is really straightforward and simple. As you all are well aware, the Constitution guarantees Belizeans the right to freedom of movement within the territory of Belize, subject, of course, to a number of accepted restrictions. These restrictions are laws making reasonable provision in the interest of, for instance, public safety, restricting movement in the interest of public safety. So the Public Safety Act is one of these laws that the Constitution allows for restrictions to be placed on the freedom of movement in certain circumstances.
Governor General Sir Colville Young signed the SI into law, citing the risk factor of civil commotion that could result in a threat to public safety. The PUP says there is not any risk to public safety.
The law itself is predicated on whether or not the determination that there existed such a risk is justified. And the challenge to the constitutionality of it lies in the simple contention that there was really no risk of any civil commotion threatening public safety. Now, civil commotion is a legal term. There's common law defining it. And what it means in the main is an insurrection of the people that's of a magnitude little greater than a riot and a little less than a civil war. We're saying that there was never any risk of that, and there was no rational basis on which the power to pass an SI to restrict freedom of movement could validly and justifiably be passed.
By the time the claim reaches its peak in the court, the statutory instrument would have already been dissolved, leaving the PUP filing against a law that isn't there. Attorney Marszalek says they have considered the time frame involved.
That is a practical consideration and one that we bear firmly in mind. The consequence of it is that it is very likely, in fact, near certainty, that by the time the claim comes on for hearing, the law would effectively have been spent, in that the 30-day period for which the restriction is to last would have expired. What that means is that the consideration of the legality of it then becomes somewhat academic, in that the court is being asked to consider the legality of a law that's no longer in force, well, in practical terms.